Ms. Jackson. Counsel?
May it please the court. Assistant Attorney General Stephen Ake on behalf of the state of Florida, the petitioner in this case. In 2017, following the U.S. Supreme Court's decision in Hurst v. Florida, and then this court's decision in Hurst v. State, the respondent filed a successive post-conviction motion under Rule 3.851, and the circuit court granted him a new penalty phase based on Hurst. The state did not file an appeal from that order, and then his resentencing had not taken place as of this date. And in early 2020, following this court's decision in Poole, the state filed a motion to reinstate the 2 death sentences that Mr. Jackson had. The circuit court ruled that it lacked jurisdiction to entertain the state's motion based on 2 cases, one being Simmons out of the 1st District Court of Appeal, and the other being this court's decision in Taylor. The state now is seeking this court's invocation of the all writs jurisdiction in order to issue an order directing the circuit court to reconsider the state's motion on the merits. It is the state's position that the court does have jurisdiction over that proceeding. The order granting a new penalty phase was not a final order because there is still judicial labor that needs to be taking place, in the sense that a
Mr. Hague, wasn't that the rationale of the 5th District Court of Appeals finding that this kind of order wasn't a final order in Taylor?
Yes, Your Honor. And Taylor,
wasn't that rejected by a unanimous Supreme Court in disapproving Taylor?
In Taylor, Your Honor, this court dealt with an order that denied the guilt phase claims and granted resentencing phase. And in nowhere in Taylor did this court address the circuit court's ability to reconsider the order granting relief. What Taylor said was trying to cure a procedural trap for a pro se defendant because he didn't appeal his guilt phase claims. And Taylor did say, has some language that the
but you would concede that under Taylor and other cases, this would be the June 2017 order would be a final order in the post-conviction proceeding, correct?
It is, according to Taylor, it is a final order for the purposes of appeal. I believe.
Do we have a third category of orders that are final but not final? I mean,
I agree that the terminology is probably not the best, and there's definitely some confusion out there regarding that. In a 3851, when the court grants relief, the state is entitled to appeal that. However, it's not final in the sense that there's still judicial proceedings that must take place between the calls of the parties. The same parties that are involved here. The circuit court still has jurisdiction.
But aren't there consequences if something is final? And I'll even grant you the for purposes of appeal, although I don't know that we have a distinction of final for purposes of appeal and not final for other purposes. But assuming that we do, doesn't the law say that if you don't appeal and raise an issue with respect to that order, you waive it? I mean, that's one of the basic finality principles that governs every kind of case and every kind of proceeding and every kind of final order. Wouldn't you agree?
Well, I agree in orders that are final, Your Honor, and that's where we have the distinction here, is that this is not a final. This is.
But I mean, you conceded that it was at least final for purposes of appeal. Or are you arguing that we should recede from Taylor?
Yes, exactly. From some of the language in Taylor, I think the problem with Taylor is that it conflates different, as you pointed out, the finality for purposes of appeal section. And in Taylor, it said it went as to the post-conviction motion as opposed to the cause. And I think therein lies the difference in it. If you look at the 1st District Courts of Appeals opinion in Rogers.
I mean, there are a lot of places that we go, but let's start with that. I mean, back to my question, if you concede that it is, Taylor properly found that this kind of order was final for purposes of appeal, doesn't it mean that you had, when you didn't appeal and didn't raise the issue, you have waived the issue by failing to challenge the final order that you're now trying to raise?
Well, no, Your Honor, because again, I don't believe it's a final order that when the circuit court has an inherent authority to reconsider rulings based on a change in precedent, that court still has jurisdiction over the cause. The trial court is the one that granted the order allowing a resentencing, and then the case is still sitting in that trial court's jurisdiction, and the court now, based on Poole, realizes that Mr. Jackson's death sentence has never had any constitutional error in them whatsoever. So now
you say that the court has jurisdiction, but there are other cases, Galindez, I think, is one of them, that the unanimous Florida Supreme Court said that a sentence that's been vacated is a nullity. So that the proceeding that's before the trial court after the final order that you didn't appeal puts the case in a posture of an unsentenced defendant, with the prior sentencing decision being a nullity. So are you saying that Galindez was wrong in that respect?
I'm not familiar with that ruling, Your Honor, but in the sense that his conviction has been final, he has not been. He had been sentenced. It was a legal sentence, and the trial court granted a resentencing proceeding with the expectation of a possible new sentencing hearing. That has not occurred at this point in time, and until that occurs, it's not final. And that's our position. And
counsel, can you address the issue though of the separate proceeding? Because it seems like that's really what it comes down to. I mean, I think if it were the same proceeding, then, you know, waiver aside, I mean, if the court arguably would have an inherent authority to reconsider its own decision, which is what I understand you to be saying. But it seems like the real hurdle for you here is the precedent saying that essentially the one proceeding, the post-conviction proceeding ends, and we, you know, either revert to the original underlying proceeding or it's a third proceeding. I don't know what the right way to think about it is, but essentially it's no longer in a situation where the court is reconsidering something on its own in the same proceeding. It's a different proceeding. So could you address that?
Yes, Your Honor. It's still the same proceeding. It's still the state of Florida versus Michael Jackson. It's still the same case number. It's still the same circuit court judge and the same parties involved in this case. We do label things post-conviction, and we have to, you know, say that the post-conviction court granted the motion, but the underlying cause and what this court has said in some of these cases as to finality is when there's still judicial labor that must be expanded in the case, it is the cause that you're looking at. And that's what we're arguing in this case, is that because it's the circuit court and he has the inherent authority to reconsider his own prior ruling, and we would submit that there's nothing in the case law or in statutes or in rules that prohibit this.
I mean, Taylor, I'm just looking at Taylor right here. It says, as we've previously explained in other cases, post-conviction proceedings and resentencing proceedings are separate, legally discrete proceedings. And then it cites a case. And I'm not sure that what is cited there necessarily supports it as strongly as what's said. But I mean, it does seem like we would have to backtrack from that in order to be able to give you the relief that you're asking for.
I think this court may have to backtrack some from the dicta in Taylor. I do believe that's the case. I think there's some language in there that this court may have to recede from. And I understand that when there is a new penalty phase that is a separate proceeding, our position is that has not taken place yet. So there is no separate proceeding in this case. Had Mr. Jackson had that new penalty phase, then obviously all bets are off and jeopardy would have attached. And this is the only remedy that the state has at this point, because if he goes back for a new penalty phase, he may get a life sentence, at which point we can't do anything about that, or the court may reimpose death, but the court will still have gone through the needless penalty phase based on Poole that we didn't need to, for the circuit court to go through all that cost and anguish to the victim's family. So I think that what we need is for this court to adopt basically the rationale of the First District Court of Appeal in Rogers, which was the en banc decision that overruled Simmons. I think that court got it right, the rationale there, as far as even though something may be appealed by the state, in this case, the granting of a new penalty phase, it is not final for the purposes of the divesting the lower court of jurisdiction to reconsider its prior ruling. If there are no further questions, I'm willing to save my time for rebuttal.
Before you go,
Okay.
you would agree that Rogers dealt with 3800, which is a rule that allows issues to be raised at any time, and even the Rogers court distinguished and made clear that that's different from 3850, which is similar to 3851, which has the strict time limit that is greatly enforced.
Yes, Your Honor. Both Simmons and Rogers were 3800 cases. I still think the rationale of the Rogers court, and they do distinguish the rules, 3851 versus 3800, but I still think the logic of the proceedings haven't finalized yet, therefore the court has inherent jurisdiction to entertain it. I will save my time for rebuttal. Thank you.
All right, thank you. Counsel, you're recognized.
May it please the court, my name is Maria DELIBERATO, and I represent the respondent, Michael Jackson. This court should unequivocally deny the state's extraordinary request to reverse a 3-year-old binding final order, an order from which the state affirmatively declined to seek any timely appellate relief. Reinstating Mr. Jackson's death sentence would be an exceptional result with far-reaching consequences and could only be achieved by ignoring the plain and unambiguous language of the Florida Rules of Criminal and Appellate Procedure. As this court has repeatedly held, all rich jurisdiction should be rarely exercised, and it is improper here where the state is using it as a substitute for their knowing and willful choice to abandon their appellate rights years ago. And so I would certainly agree with what Justice LAWSON was saying, that the state has made an affirmative decision. They've waived any right to appeal this sentence. And all writs is not proper where the state has a remedy and they chose not to use it. So all rights should be rarely used, is extraordinary, and should only be used in cases where the state has no other remedy. It's not an end around, it's not a substitute, it's not a last-ditch effort for the state to breathe life into their old abandoned arguments. And basically this court, the state is asking this court to expand its jurisdiction and impose a sentence of death by reinstating Mr. Jackson's death sentence. The state's rights to appeal in criminal cases are limited by statute. We know under 3.851 that they had a limited right. They had a right to appeal. They had an affirmative right to appeal under 3.851 F8. This was a final order. Taylor tells us that it's a final order, and they should have appealed the grant of relief if they felt that it was unconstitutionally done or whether it was improper. The state concedes in its response here that they're not seeking to reinstate any of the sentences where the defendants have already been sentenced to life. So it's no different. They can no sooner go back and take a client that has been resentenced to life where the state declined to seek death on resentencing and go in and try to take away and reinstate Mr. Jackson's death sentence. There's just no legal or procedural mechanism for them to do that. And this court does not have all rich jurisdiction here. I think Taylor is directly on point. Post-conviction proceedings and resentencing proceedings are separate and distinct. The state's argument too is disingenuous at best in the sense of it's important for not to have an unnecessary sentencing proceeding or to bring finality to the victims in this case, which is certainly a consideration for this court. I'm not denying that it is. That would have been done, but for the state's action in this case. I mean, the state filed this petition on the eve of Mr. Jackson's trial, and this court stayed the trial on a Friday afternoon, and the trial was set to go on Monday in February. This matter would have been decided, there would have been a decision one way or another, but for the state's actions of bringing this case forward and before this court and seeking this, what's effectively a Hail Mary on their part to try to renew and do a belated appeal. And that's just not what this court's all-rich jurisdiction is for. It's not what it's designed for. It's not what this court is supposed to do in order to make sure that our death penalty system is fair and just. And if the state of Florida is going to have any confidence in the death penalty, and if we have a state has decided that we want to have the death penalty, for it to be fairly and fairly applied, there has to be confidence in the process. There has to be finality. There can't be this granting the state this extra exception that capital defendants don't have. In State v. Sylvia, it's a perfect example dealing in the death penalty context. Mr. Sylvia had waived his post-conviction proceedings, he went through the process in circuit court. The circuit court found a waiver. This court upheld his waiver of state post-conviction process. Hurst v. Florida came out. Hurst v. State came out. He would have been entitled to a new penalty phase pursuant to that precedent. He did not have a unanimous sentence. The circuit court said that's an extraordinary thing that you could not have foreseen coming, and your waiver wasn't knowing. And this court reversed and said no, said that the state, that you cannot hold on, you cannot sort of hold your cards to your vest and then play them down the road when you think you have a more favorable outcome. And the state should be treated no differently here than the state was than Mr. Sylvia was. And this court has repeatedly said that procedural rules apply equally to the state and to the defense. And the state has offered no legal or procedural justification here to recede from Taylor, to change the rules. This court would have to rewrite the Florida Rules of Criminal Procedure, would have to rewrite Florida Appellate Rules of Procedure. And as this court knows, rulemaking process has to be done with notice and opportunity for public comment. And there's no possible way to give the state the remedy it seeks here without adopting a results-oriented approach. And that is inconsistent with this court's approach. That is inconsistent with reading the plain and unambiguous language of the statutes. And so I'm happy, of course, to answer any questions from the court. Having had no questions yet, but I'm certainly happy to entertain any. But there is no legal or procedural justification for reinstating Mr. Jackson's death sentence. And if there are no further questions, I will.
Can I ask you a question?
Yes.
I understand everything that you're saying on the merits. As to jurisdiction, could you sort of, what's your best argument for why we don't have jurisdiction to entertain the petition at all? Putting aside granting it or denying it, but just whether we can entertain it at all. It seems like our precedent on whether we have jurisdiction at all, that we've taken, right or wrong, for better or worse, a very broad view of our authority over anything relating to the death penalty, that sort of thing. I mean, do you think that does that apply here, or do you think the right answer is to say we can't consider it at all on the merits, period, because we don't have jurisdiction?
I think that you do not have all writs jurisdiction over this case because it is not to be used as a substitute for a remedy. And the state had a remedy here and they chose not to use it. So all writs jurisdiction is supposed to be a writ of basically of last resort when there's no other possible way for the parties to reach this court and to get to this court. And so, no, I don't believe this court has all writs jurisdiction because the state had an affirmative remedy under the rule and affirmatively chose to abandon it. So that's the distinction here which is my argument.
Thank you.
And if there are no further questions, we're asking that this court decline to breathe new life into the state's long abandoned appellate arguments and decline to reinstate Mr. Jackson's death sentence and deny the state's writ. Thank you very much.
Thank you. Mr. Wright.
Yes, just a few brief points. First, on the all writs jurisdiction, I certainly think this court has jurisdiction when it has exclusive jurisdiction over all death penalty cases. It had jurisdiction over Mr. Jackson's case before, and the case law says that when all writs is appropriate to preserve the jurisdiction that's been invoked or for protecting jurisdiction that likely will be invoked in the future. And I think both of those are applicable here. So I think under the law we cited in our petition, I think clearly this court can exercise its all writs jurisdiction. Council's arguing that we're seeking a belated appeal. That's not what we're doing. Mr. Jackson was given relief in 2017 based on Hurst. We did not appeal that decision. What we are seeking now is for the court to recognize the circuit court's inherent authority to reconsider its own ruling prior to any other actions being taken in the case causing finality, basically the resentencing. So
it does, but counsel, it does seem like there's some merit to what the counsel on the other side is saying, that, you know, basically, I mean, it seems like we frequently don't give defendants a pass when they don't appeal because of perceived futility. And it seems like the state here, I guess because of the perceived futility at the time of appealing, chose not to. And now, you know, it does seem like you're trying to get a very, you know, belated second bite at the apple. I mean, how does that make sense?
Well, again, Your Honor, I don't think we are trying to attack the underlying ruling from 2017. We now know in 2020 that it was the wrong ruling. And that is what we're trying to address here, is what is the circuit court to do in 2020, given Poole and the prospect of ordering a costly resentencing proceeding for a case that there is no reason for it. And that's what we're trying to address. It's a very specific issue as to the jurisdiction, procedural jurisdiction of a circuit court and his ability or inability to enter an order based on a change in the law prior to any finality attaching to the decision. And that's,
but there is a reason for it, in the sense that the legislature chose to change the law on sentencing. And so that's the governing law. Obviously the governing constitutional law is set by Poole, but, you know, the sentence was vacated. You guys didn't appeal. There is no sentence now. And the defendant is entitled to the panoply of protections and process that he has under the statutes as they exist today.
Well, Your Honor, I would just point out, just like in Rogers and some of these other cases where they reinstate the sentence that was previously imposed, I think that's all we're asking for, is the court's ability to reconsider it. His sentence should have never been overturned, but it was vacated and a new penalty phase was ordered. But the trial judge has to be able to reconsider its own rulings. I think there's nothing that prohibits that in the statutes or in the rules as to specifically on that point of the trial court's inherent authority to reconsider its own ruling. And we would ask this court to issue an order to the court to consider the state's motions on the merits, and that it does have jurisdiction to address that. If there are no further questions, thank you.
All right. Well, we thank both of you for your arguments in this case. And we'll now move on to the fourth and final case on today's docket, which is the state of Florida versus Okafor.